Arbitration and litigation in the court are two sides of the same thing. They are both litigation type vehicles. Mediation, on the other hand, is trying to resolve matters, and it's not binding until the parties agree on something. The primary benefit to litigation is that you're in the court system, which allows you to get discovery, which means to obtain documents and testimony of the other side and find out what they have and what information they have. There's much smaller amount allowed in arbitration, if any. The negative part about litigation is the time and the cost. You go through litigation and you find that it may be hours and hours and hours and days, and that's very costly to have attorney time involved, plus the fact that the courts are backed up and sometimes it's 3 years till you get a decision. In arbitration, it's a streamlined process. Sometimes within 180 days, the whole problem is resolved. And so the cost is reduced in that respect, but then you have the cost of the arbitrators. You got to pay the arbitrators. The people pay the judges. The arbitrators are paid privately. Mediation can occur in either of litigation or arbitration. In the commercial parts, the courts have been assigning cases to mediation on a regular basis. And I found it to be very successful more than 50% of the time. In arbitration, a lot of times the arbitrators will suggest mediation before they get to the final resolution. Or sometimes in the middle of the arbitration itself, they will sit down and say, let me see if we can mediate this and see if we can get it resolved. So it is a very effective methodology. There are various things where arbitration is much more helpful. Issues such as internal business disputes. A lot of times those can be resolved by arbitration. I put arbitration clauses in a lot of the contracts that I do because of that. I also look at, there are times where litigation is much more effective, when there is much more issues of fact, questionable, difficult legal issues. Litigation would be a lot better. Usually those don't involve arbitration clauses, because once there's an arbitration clause in an agreement, you have to arbitrate. No. What you can do is you can bring a motion in the court. The arbitrator's decision has to be confirmed by the court under the provisions of the civil practice law and rules. And if you don't like the decision, you can ask that the decision be thrown out, but only on the basis that it was arbitrary and capricious.